All right, welcome everybody. My name is Zach Sarkis. I will be your host today. You are here with Hemp Lab. Check out the shirt. That's right. We have two great, some of the two leading attorneys, cannabis attorneys in New York State that are with us today that will be offering perspective for the next 5 Tuesdays, exploring the proposed MRTA, the Marijuana Regulation and Taxation Act. So every Tuesday you can see February 23rd, March 2nd, March 9th, March 16th, and March 23rd, we'll be covering primary topics of the MRTA from noon till 1:15. Super grateful for everyone who's registered thus far. Welcome to everyone who's live in the audience right now. And yeah, the idea is to create a space for conversation and digestion. This is a workshop. This, we're taking this casually, as well as, we all carry this pretty close to heart. So please make sure you come to future workshops, because this is just a start. Bring your questions. We got the chat, we got the Q&A box. We will do our best to answer questions, especially with regards to the context that the question is asked in. If it's on subject, great. If it's not, we'll try to address it later or towards the end of the call. First hour is we're reading line by line. And then the last 15 minutes, we generally try to offer more Q&A. So really, yeah, appreciate everyone who's on board today, and we're going to keep moving forward. Got to give a big shout out to our founding sponsoring members, Boil & Code, Canamil, Forefathers Innovation, Singer Farms, the NYC GPA, Dawson Law Firm, and Tracy Jong. And also huge shout out to our sponsoring member, Harris Beach. They've just, honestly, with all of y'all, we wouldn't be here without you. So thank you so much. We also got a few new members on board. I can't remember them off the top of my head, but we've got a bunch of individual members who've been signing up, and please know that your contributions keep the Zoom calls on, keep the lights rolling. So we can't thank you enough for your support. This is a community initiative run by a board of volunteers, and sincerely, every contribution helps us have the budget to make sure that we're able to promote and give this to the public and keep it affordable. That's the biggest thing. So I'm going to just switch my share real quick. We're going to put on this. We'll be drawing from the version of the MRTA that's in the Senate. And today we are focusing on the definitions and then exploring the board of cannabis, the Cannabis Control Commission. Elise and Jason, if y'all want to just add a little 2 cents as to why you think it's important we start with this kind of segment. Obviously it sets context, but we're all ears.
Sure, Jason, you want to go first? You want me to?
Go ahead, Elise.
Sure. So hi, everyone. My name is Elise Burgio. I'm the team leader of the cannabis service team at Barclay Damon. And I also am the chair of the New York State Bar Association's Cannabis Committee. I love the way that kind of Zach and Jason, I know they did this in the hemp extraction bill, but this is the most informative way to understand how our laws are created. And definitions are easily the most boring component of this, right? Because you're just like, we're just doing defined terms and going over the overview and things like that. But breaking down all the intricacies of things that you might not really be thinking about, right? Some important topics are going to be like how many licenses you can have. Are you going to have to do multiple applications? What does cannabinoid mean? How are they defining it? How are they defining THC content for taxation purposes? All those things are really important for us to dive into, and I can't think of better panelists to work with that really understand the law very well. So Jason, you go ahead too.
Yeah, I would just add to that. Well, first of all, I'm Jason Klemick. I am the chair of the Cannabis Practice at Boil & Code, also on the Cannabis Law Committee with Elise. I would just add to that like this is how we as lawyers look at things. We look at the definitions because oftentimes a colloquial definition is not how the law defines it. And when we're talking about the law, we care about how the law defines it. So, it may sound boring, but this is realistically a lot of times where lawyers start when they're interpreting statute and things like that. So it's really important to kind of understand, and provides a great basis for the rest of the law.
Yeah. And again, we're so lucky. Thank you, Elise and Jason, for being here today, and looking forward to diving in. I'm going to scroll down to where the definitions start. So from the beginning. So context, I'll kind of take the lead here, and we'll dance back and forth between who's reading what. I'll probably read a couple at a time and then hand off to Jason and to Elise. And again, folks, the intention of this platform is to create conversation around this bill and what's in it. And we start here because this is where the rest of this bill is built off of. So definitions. Wherever used in this chapter, unless otherwise expressively stated or unless the context of subject matter requires a different meaning, the following terms shall have the representative meanings hereinafter set forth or indicated. Applicant means a resident. So you'll see my highlighted stuff on the screen. Please, you can either emphasize or reiterate, or don't be distracted by it. But applicant means a resident of New York State who is a citizen of the United States or person lawfully admitted for permanent residency in the United States, age 21 years or older, applying for a cannabis or hemp license or special use permits issued by New York State Cannabis Control Board pursuant of this chapter, provided, however, the applicants for hemp licenses may be aged 18 years or older. Cannabinoid means phytocannabinoids found in hemp and does not include synthetic cannabinoids, as that term is defined in the subdivision G of Schedule 1 of Section 3300 of the Public Health Law. So I just put a little question here, what about THC? It's interesting that, they say it's just derived from hemp, and I just you guys got any thoughts on why?
So I think, to be honest with you, I also want to put this as the caveat. This bill hasn't been updated in its form. I know that they did it in I don't know, when was C revised, Jason? Do you remember? I think it was maybe ended 2019, 2020.
Yeah, about a year ago.
And so I do think these definitions are going to be a little outdated, given the way that they've redone the hemp extraction definitions and just the way that CRTA define their definition. So if the MRTA is the bill that's passed, I do anticipate seeing some of these having to be reworked to be congruent with how they've already passed other legislation. Especially with the definition of cannabinoid, right? Because they did cannabinoid in the extraction bill.
Yeah, I agree. And I do think that folks, I see a couple of questions in the chat already. Thank you so much. When it comes to business and business size, the adult use workshop, which is our next workshop, is really going to dive into the licensing. So I think we can talk more about the size and volume and what that means. And there aren't a lot of specifications in these bills. These are just general parameters. And I think we're going to see a lot more regulatory framework as it moves forward. But I do want to acknowledge that. And folks, we've also chosen to go with the MRTA instead of the CRTA because the foundations of the tax proposal of the CRTA as it stood a month ago or a couple of weeks ago, to us as professionals seems dead in the water, as well as other provisions that are necessary for small business, for equity and opportunity for New Yorkers, regardless of wealth, of color, et cetera. So we're choosing to look at the MRTA because we think as a standalone, it is something that folks can rally behind. It's not perfect. And there's, again, opportunity to ask questions, but I just want to create that context as we move forward.
And Zach, not to jump in too heavy, but the CRTA, we're going to pepper in kind of the differences between the MRTA and the CRTA, just so you guys kind of have a hold of why we're choosing to focus on the MRTA because of what we're seeing in the CRTA.
Yeah, great. I appreciate that. Jason, you want to go after cannabinoid hemp?
Sure. So cannabinoid hemp means any hemp and any product processed or derived from hemp that is used for human consumption, provided that when such product is packaged or offered for retail sale to a consumer, it shall not have a concentration of more than 0.3% delta-9 THC. Important, 3% delta-9, not total. So divergent from USDA, FDA kind of things. Just important to understand. Cannabis means cannabinoid hemp processor license means a license granted by the department to process, extract, pack, or manufacture cannabinoid hemp or hemp extract into products, whether in intermediate or final form, used for human consumption. Cannabis means all parts of the plant of the genus Cannabis, whether growing or not, the seeds thereof, the resin extracted from any part of the plant, and every compound, manufacture, salt, derivative, mixture, or preparation of the plant, its seeds or resin. It does not include the mature stalks of the plant, fiber produced from the stalks, oil or cake made from the seeds of the plant, any other compound, manufactured, salt, derivative, mixture, or preparation of the mature stalks, except the resin extracted therefrom, fiber, oil, or cake, or the sterilized seed of the plant, which is incapable of germination. It does not include hemp, cannabis hemp, or hemp extract as defined in this section. And I think that is a really, really expansive definition. That's basically saying everything other than like the stalks and what we define as hemp is cannabis. So there's, in my opinion, there's no question that Delta 8, which has become very popular, is covered under cannabis. So it's Delta 8 is still cannabis for the purposes of this law. And therefore covered by it. Cannabis consumer means a person 21 years of age or older acting in accordance with any provision of this chapter. Cannabis
Scroll down
Control
for you. Yep, great.
Board means the New York State Cannabis Control Board created pursuant to Article 2 of this chapter. Cannabis flower means the flower of the plant of the genus Cannabis that has been harvested, dried, and cured prior to any processing, whereby the plant material is transformed into a concentrate, including but not limited to concentrated cannabis or an edible or topical product containing cannabis or concentrated cannabis and other ingredients. Cannabis flower excludes leaves and stems. Cannabis product or adult use cannabis product means cannabis, concentrated cannabis, and cannabis infused products for any use by a cannabis consumer. Cannabis infused products means products that have been manufactured and contain either cannabis or concentrated cannabis and other ingredients that are intended for use or consumption. Cannabis trim means all parts of the plant of the genus Cannabis other than cannabis flower, which have been harvested, dried, and cured, but prior to any further processing. Caring for means treating a patient in the course of which the practitioner has completed a full assessment of the patient's medical history and current medical condition. Certification means a certification made under this chapter. Certified medical use includes the acquisition, administration, cultivation, manufacturing, delivering, harvesting, possession, preparation, transfer, transportation, or use of cannabis or paraphernalia relating to the administration of cannabis to treat or alleviate a certified patient's medical condition or symptoms associated with the patient's medical condition. Certified patient means a patient who is a resident of New York State and receiving care and treatment in New York State as determined by the board in regulation and is certified under this chapter. Chief Equity Officer means the Chief Equity Officer of the Office of Cannabis Management. Elise, I'm fairly certain that CRTA doesn't have that, right? They don't have a Chief Equity.
They have a social equity director.
Okay.
So they have it's like the only two appointed positions are a social equity director and a budget director are the only two positions that have been approved. They're not in the legislation, but they were put in one of his press releases. So.
Okay. All right. Commercial cannabis activity means the production, cultivation, manufacturing, processing, possession, storing, laboratory testing, packaging, labeling, transportation, delivery, or sale of cannabis and cannabis products as provided for in this chapter. Concentrated cannabis means a separated resin, whether crude or petrified, obtained from a plant of the genus Cannabis or a material preparation mixture compound or other substance which contains no more than 3% by weight of Delta 9 THC or its isomer Delta 8 numbering system or Delta 1 tetrahydrocannabinol or its isomer Delta 1 or some other ones too.
So I think that's really important that it's interesting, right? That this bill included Delta 8 way before it was in any other type of bill. And it's indicative of how in tune the MRTA is with the actual industry, in my opinion, because they understand how operators are currently, processing and producing hemp, and then it's transitioned to higher THC to make it marijuana. But for those who are dabbling, I know a lot of people are in Delta 8, even though it's not necessarily indicative in the federal level to the extent where it's out, spelled out, I do think that's just going to keep, the more momentum it comes with the consumers purchasing it, it's just going to keep getting regulated at a higher level.
And I think it's also important to note that they accurately put it in concentrated cannabis because it is not generally not naturally occurring. So I won't blanket statement that we'll never see it. But as most Delta 8, to my understanding, is being manufactured downstream from CBD or CBDA. And I think, again, that's just, they have their pulse on where the industry is and how it's actually happening. Now they're not banning it. But it's being regulated as a concentrate. And I think that's just important.
That's kind of part of the thing too about the MRTA and CRTA differences, I think, is that the MRTA was crafted with this knowledge of the industry and looking for input from, the industry. And I think the CRTA is much more just regulatory driven, financially driven, business driven. So I think that produces some of the differences we see in the bills.
Great.
100%.
Elise, you want to take the condition and we'll move forward from there?
Sure. So this is in relation to the medical marijuana regulation. It means having one of the following conditions: cancer, positive status for human immunodeficiency virus or acquired immune deficiency syndrome, scoliosis, Parkinson's disease, multiple or MS, damage to the nervous system, spinal cord with objective for neuroindication of intractable spasticity, epilepsy, IBD, neuropathies, Huntington's, PTSD, pain that degrades health and functional capability, where the use of medical cannabis is an alternative to opioid use, substance use disorder, Alzheimer's, muscular dystrophy, rheumatoid arthritis, autism, or any other condition certified by the practitioner. And then cultivation, which means growing, cloning, harvesting, drying, curing, grading, trimming of cannabis plants for sale to certain categories of cannabis licenses and permit holders. Do you have a comment there too?
Yeah, just a little one. It's like, does this mean I need a cultivation license to trim? Like if I want to start a business that is purely trimming, and that's where I'm curious for small businesses finding their niches within this industry. We'll address this downstream as we look at the specific breakdown of licenses, but that was just a question for me, who I've had experience trimming, and I know that there's value in the marketplace for offering that service. So do I need a cultivation license or is it a processing license? And just a question for us to keep reflecting on.
Or is it pertain to the nursery? Could it be part of the nursery license, right? Or no?
Yeah, nursery is, I would categorize that as like seed until till sale of a living plant, whereas the trimming is that I'm speaking of is definitely post-harvest.
Post-harvest, yeah.
I mean, it's kind of like dry. You can wet trim, but the specific model of trimming I'd be speaking to is dry trimming.
It's post-harvest, yeah.
Yeah, but yeah, cool.
Delivery, and also just put a couple asterisks near this one, as the delivery license has been a very contentious issue in the two bills. The CRTA just in their amendments put delivery license back in, which it was smart of them because not having delivery license is very silly. But so delivery means the direct delivery of cannabis products by a retail license, micro business license, or delivery license holder to a cannabis consumer. I think that's important because micro businesses allowing a delivery license is that's a nice perk as the retail license, or we're going to see you having an opportunity to just be a full service delivery carrier.
It's interesting. The fine print too on the delivery is fascinating. Like you can only hold X amount of permits, and it's up to a certain number of employees, which I thought was fascinating. Again, we'll cross that later, folks.
So designated caregiver facility means a general hospital or residential healthcare facility operating pursuant to Article 28 of the Public Health Law, an adult care facility operating pursuant to Title II of Article 7 of the Social Services Law, community mental health residence established pursuant to Section 4144 of the Mental Hygiene Law, a hospital operating pursuant to Section 717 of the Mental Hygiene.
A lot in here about the specifics, and like we could probably do a full workshop on the medical.
You can kind of skip over this, right? Like a lot of the medical stuff, guys, has not changed. So you can be a certified facility, you could be a certified, designated caregiver. That's all stuff that hasn't been changed. So we might not want to take up too much time on that because these aren't new definitions, and we've had a medical program for the past, I think, 5 years now, 6 years.
6 years.
Yeah.
Right.
So,
Yeah. Great.
yeah, so maybe we'll just jump to distributor. And I think this was one of the questions has been about distribution. And a distributor means any person who sells at wholesale any cannabis product except medical cannabis for the sale of which a license is required under the provisions of this chapter. Just to kind of give you a quick, and I've had this conversation a lot about people talking about distribution licenses, and I don't want to get too much into the licenses because that's another topic, but there's a lot of fear that the alcohol distributors are going to be taking the place of people on these distribution licenses. And I almost think that they don't really have any leg up on anyone. I mean, distribution in cannabis is so much different than distribution in alcohol. Like, they don't have the connections with the retail stores. They don't have, they have the logistics in place, but they're not part of this existing infrastructure. And so really all they're talking about is that maybe they have the business end of it. But in terms of connection points, I really don't think that these alcohol distributing companies have any more of a leg up than somebody who's been in this industry for 10 years and knows who's going to get a retail license, is really involved in the market. So just something to think about when we talk about distribution.
I would definitely agree with that. And I'm pretty sure that the MRTA forces you to either have a distributor license as like a cultivator or processor, or go through a distributor in order to get down to the retail level. And the argument for putting it in there was that they have this knowledge of dealing with a highly regulated industry and things like that. But then again, if you can hold a distributor license as another licensee, then I don't know if that argument really holds a lot of water.
Yeah, and I'll just do this next one, and then we'll go back to you, Zach. The executive director means the executive director of the Office of Cannabis Management. For those who don't know, that's going to be Norman Bierbaum. He was already appointed about 1.5 years ago as the ED. It's not changing in the MRTA, and it wouldn't change in the CRTA. But something to really think about, and we're going to get more into this. We've talked about a cannabis board. We've talked now about the executive director. What we're going to see is a big discrepancy between both, because in the CRTA, Cuomo gets to appoint all of his board members. And as you'll see in the MRTA, Cuomo doesn't have as much discretion over that. And so that type of power is going to be really important, because these are the people who are going to be approving the licenses, penalizing you, giving you preferential treatment, letting you know whether or not you qualify as a social equity applicant. So they hold a lot of power.
It's very true. And that's one of the big differentiators of why advocates stand in favor of talking about the MRTA, because of the checks and balances that are innate in this bill. And again, we'll look at that in the next section in probably the next 20 minutes or so. So form of medical cannabis means characteristics of the medical cannabis recommended or limited for a particular certified patient, including the method of consumption and any particular strain, variety, and quantity or percentage of cannabis or particular active ingredient. Hemp means the plant Cannabis sativa L and any part of such plant, including the seeds thereof and all derivative extracts, cannabinoids, isomers, acids, salts, and salts of isomers, whether growing or not, with delta-9 THC concentration of not more than 0.3% on a dry weight basis. It shall not include medical cannabis as defined in this section. Curious, just a question comes to my mind. Well, what about people who are growing hemp in a medical situation? I mean, it's probably just considered under the definition as a medical cannabis product, even if it has below 0.3%.
Right.
Also beginning to see, fingers crossed, as a cultivator and someone who has a lot vested in this hemp space, that the slim but possibility that the definition of hemp is increased to 1% THC, total THC. And as we've talked about before on this platform, that the 0.3% delta 9 THC is an arbitrary number that was designated to determine if a cannabis plant is predisposed to be a resin variety, differentiating from a grain or fiber. Had nothing to do with it to be psychotropic or to be something that could be abused. So I'm hopeful that maybe we can get that number up to 1%, but just important to acknowledge that as it stands, it's still at 0.3%.
So Zach, I don't think it's far-fetched that could be 1%, especially if, God forbid, the CRTA is passed. And we're talking about calculating THC is much more scrutinized.
Mm-hmm.
One respect there is a strong possibility that they could break down hemp at a larger percentage, especially now given with the new EA final rule where they're mentioning 1% is like almost allowed in terms of rectifying your over 0.3.
No, I love that perspective. Appreciate it.
Yeah.
Hemp extract means all derivatives, extracts, cannabinoids, isomers, salts of isomers derived from hemp used or intended for human consumption for its cannabinoid content with a delta 9 THC concentration of not more than an amount determined by the department in regulation. For the purpose of this article, hemp extract excludes any food ingredient, or food additive that is generally recognized as safe, which is, is it GRS? That's just like the way we'd see that. GRAS, so GRAS, which is just something terpenes are recognized. Some terpenes are recognized as GRAS, where cannabinoids are still not. That goes back into FDA and federal recognition, et cetera. But so an additive that is generally recognized as safe pursuant to federal law, or B, any hemp extract that is not used for human consumption. Such excluded substance shall not be regulated pursuant to the provisions in this article, but are subject to other provisions of applicable state laws, rules, and regulations. Okay, labor peace agreement means an agreement between an entity and a labor organization that, at a minimum, protects the state's proprietary interests by prohibiting labor organizations and members from engaging in picketing, work stoppages, boycotts, and any other economic interference with the entity. That's an interesting language. I don't really know too much, but protecting the state's proprietary interests. I don't know if y'all have any insight on that, but it's interesting for me.
So labor peace agreements are kind of an interesting, we're seeing it heavily in New Jersey. We've obviously seen it now it's in both bills, both CRTA and MRTA. I don't know if the language is significantly different, but ironically, the northern states, Michigan, Illinois, New York, New Jersey, I'm pretty sure it's in Massachusetts, all have these requirements that you have to have a labor peace agreement and almost have a good faith basis of working with the unions, which you don't see if you looked at other medical marijuana, or you look in the South at medical marijuana states, they don't have this language in there. So
something that's interesting too, I've been noting, is the definition of agricultural worker versus ability to unionize. And there's it's something I can share with y'all later, but there's a lot to be said about who's an employee under what standards, especially if we're in agriculture, or are we not in agriculture, and what role is trimming an agricultural service, or is plant caretaking just an agricultural service, and that and how that allows people to organize and protect their interests, et cetera. So I think there's a lot to be said here.
You're seeing also now the unions are really starting to take a pro-cannabis approach now with efforts. I'm blanking. I think it's out of New Jersey, or it's definitely the East Coast, that has been putting a lot of money into lobbying for these labor peace agreements. So it's very interesting in the context of what will be required for an application. You're going to most likely need to have this LPA before you're applying.
And an LPA is required at a certain point of, again, I think we'll look at this downstream, but a certain number of employees, I think, is it 25? Above 25, you must have it.
Yep.
Yeah, great. All right, so on to the next. Laboratory testing facility means an independent laboratory capable of testing cannabis and cannabis products for adult use, medical use, hemp, cannabinoid hemp or hemp extract, or for all categories of cannabis and cannabis products as per regulations set forth by the State Cannabis Control Board. License means a written authorization to provide under this chapter, permitting persons to engage in a specified activity authorized pursuant to this chapter. Licensee means an individual or an entity that has been granted a license under this chapter. Medical cannabis means cannabis as defined in this section intended for certified medical use as determined by the board in consultation with the Commissioner of Health. Microbusiness means a license that may act as a cannabis producer for the cultivation of cannabis, a cannabis processor, a cannabis distributor, and a cannabis retailer under this article, provided such licensee complies with all requirements imposed by this article on licensed producers, processors, distributors, and retailers to the extent the licensee engages in such activities.
Also known as full vertical integration, which typically would be prohibited on the adult use side, except for the fact that we know that they're going to limit the production capacity somehow. We don't know by what amount. That'll clearly be done in regulation.
So I was just looking at New Jersey's bill, and I think that they limited their micro licenses to like less than 1,500 square feet of canopy, which is parallel to like what Oregon did. I think Oregon went up to 1,250 for their micro licenses. And it's interesting, and I'm sure with everybody on the call here today, there's been a lot of almost gossip about how big these can be. And I know I had 2 clients mention that they thought that it was going to be 10,000 square feet of allotment for canopy. And I got to tell you, I think that's insane. Only because 10,000, first of all, if you can do 10,000 square feet of canopy, why would you go for a regular license if you could be vertically integrated with that amount of space? And second, that was the largest tier. That was tier 2. So you could get out of Oregon would be for 10,000 square feet. So micros are going to be a really interesting topic moving forward.
Sure.
Zach, what would you ballpark the number of plants on like 1,500 square feet ish?
Depends if it's indoor or outdoor. Greenhouse, it's
let's say
I do think honestly the future will be more canopy size versus plant count. Honestly, 1,500 square feet. Let me think about that. I can't pull that off the top of my head, but that's a great question because literally what is that size literally? Is that it's like the dimensions of a 1,500 square foot, it's 150 by 100, correct?
Yeah, well, and also, I mean, it would be because they provide canopy square footage, therefore vertical farming is included in that. So if you could have a 1,500, let's just say square feet, it doesn't necessarily have to be 1,500 square feet in area. It could be, 1,500 square feet that includes height. Because if you didn't include height, you could have way more than 1,500 square feet.
Oh, it looks like James has the right number. So it looks at 2,500 for max 10 employees. I want the newest bill. I know they just passed yesterday, the New Jersey stuff. I haven't looked in a couple weeks. So
cool. No, thank you, James. I love that. And just there's one question in the Q&A I just want to acknowledge. Would a hemp cultivation license help in acquiring a marijuana cultivation license? There is conversation about that. There's nothing set in stone. NYCGPA has been working hard to have there be a doorway for existing hemp cultivators. It's not certain that will be the case, but I think we'll learn more in the coming months. So let's keep our ears to the ground, Sibby.
I think the real big tackling for that is going to be whether or not hemp falls under a social equity applicant for a disadvantaged farmer.
Yeah, and it's just because you're cultivating hemp. I mean, there's folks in New York State who are growing high quality, indoor cultivation with a greenhouse with acres, who are operating with a substantial budget. Where there are some folks who are literally, making
farmers who have just been doing it,
making ends meet through their farm, and they're integrating cannabis into that. And I think that there's definitely going to be a role to play there.
Totally.
All right, Jason, go ahead.
But from what I've heard too, there's at least from some perspectives, there's going to be no preference given to hemp farmers unless you fall into one of those categories.
Correct. Yep.
So it's all in who you're talking to at the moment, and we have yet to see what's actually going to be decided.
I also think that you can't underestimate the power that an individual has in terms of the group that is suing Governor Cuomo for the flower ban, right, at the hemp aspect, for smokable. Those things take notice. in the governor's office, and the guy doesn't really like to have his back against the wall. So I wouldn't be surprised if there are some concessions down the line on, some sort of leg up for hemp operators in either bill. But I could be reading that wrong. But that's how I think he operates. Just in the past.
Cool. All right, take it away, Jason.
All right, nursery means a licensee that produces only clones, immature plants, seeds, and other agricultural products used specifically for the planting, propagation, and cultivation of cannabis. Office, or Office of Cannabis Management, means the New York State Office of Cannabis Management. On-site consumption means the consumption of cannabis in an area licensed as provided for in this chapter. Important point, I believe the CRTA did not include that, or took it out, and it has not been re-included in the amendments. So big difference there is you can't have, the equivalent of like a bar for cannabis. Although, and correct me if I'm wrong, but those don't seem to be super popular in other states. Like, it doesn't seem to be a huge business model. I'm not saying that it shouldn't, be included, but it doesn't seem to be something that is very, very popular. It seems to be more of the dispensary model is much more common or delivery.
I did hear that it was actually really popular in Oregon in the early onset and transition, and then they shut it down. And it was actually a pretty big hit to the local economy and local entrepreneurs. And we see stuff happening in California. It's what's one of the biggest issues is it hasn't been permitted on the onset. And I think there's still this recreating culture post criminalization. So I'm curious to see what it will do, but I do think that there's a place for it, and it may be like events specifically versus a lounge. But there's a half dozen hookah lounges across Rochester, and it's like I would imagine that there's some places that could be successful, and it all really comes down to your business model and your branding, marketing.
Zach, I was actually in Oregon when they shut down this OG cannabis cafe in Southeast Portland. And it was a really big issue because they were allowed it under the medical program. And then when adult use came into play in 2015, 2016, they didn't include it in the legalization bill, and then they all got shut down. And so it wasn't in the OG bills. It hasn't really been in a lot of the legislation that's been passed originally, but I'm pretty sure Denver, either 2 years ago, I think 2019, does have social consumption lounges now. But again, they find later on that they're adding it. And Jason and I run a CLE with Norm Birnbaum and Axel out of the governor's office. And they said that this isn't like a completely opted out situation, but it might be a license that they put into play later on the line, which I think is, if it's the CRTA, not the MRTA, what we're looking at right now. And I think that is a strong possibility that if they find people who don't have anywhere to consume marijuana, that's a big issue, right? Because they don't want people in their cars, they don't want people in their housing and on the street. So
right. And also just interesting from a legal perspective too is what is the liability? Because if a bartender overserves somebody in a bar, they can have liability for that. So and what is overserving somebody cannabis? So very.
I don't think, Jason, that they're serving you cannabis. I think you're bringing your cannabis to the lounge and based to smoke.
I think I remember and again, folks, this hot topic is going to come up again in the next workshop as we look at the specific licensees. But I think there are some specific parameters on if and how product can be distributed on an on-site consumption, how it has to be packaged, stored, and the relationship to distributor and or a micro business. That's all stuff I remember in the fine print. So definitely excited for that. Let's keep moving just for the sake of time. I do want to make sure we hit the control board, but we just passed on-site consumption, and now we're back to owner. If you want to keep rolling with that, Jason.
Owner means an individual with an aggregate ownership interest of 20% or more in a cannabis business license pursuant to this chapter, unless such interest is solely a security, lien, or encumbrance, or an individual that will be participating in the direction, control, or management of the licensed cannabis business. Package means any container or receptacle used for holding cannabis or cannabis product. Permit means a permit issued pursuant to this chapter. Permittee means any person to whom a permit has been issued pursuant to this chapter. Practitioner means a practitioner is licensed, registered, and certified in New York to prescribe medical cannabis. Processor means a licensee that extracts concentrated cannabis and or its compounds, blends, extracts, infuses, or otherwise manufactures concentrated cannabis or cannabis product, but not the cultivation of the cannabis contained in the cannabis product.
Here's a question I would have, like, is a processor someone who puts hemp flower or cannabis flower in a bag? Is that, like, if you're going to put something into a bag, do you have to have a processing license? And it goes back
I would
to
argue
trimming.
that would be cultivation at the very
I agree,
end.
Jason. I'm in the same boat as you.
Same with kind of your trimming question is I think that they wanted to say, look, cannabis cultivators, you can get this product ready so you can hand it right over to a processor, but you don't need to be a processor. So trimming, bagging, that kind of stuff, you can do all under a cultivation license.
Agreed.
Mm-hmm.
RO means an organization registered under the Article 3. That's medical companies. Registry application means an application properly completed and filed with the board by a certified patient. So dealing with medical registry identification card is a medical marijuana card. Retail sale means to solicit or receive an order for, to keep or expose for sale, and to keep with intent to sell, made by any licensed person, whether principal, proprietor, agent, or employee of any cannabis product, cannabinoid hemp or hemp extract product, to a cannabis consumer for any purpose other than resale. So that is the end use. And it's interesting. Well, they throw it under there because the MRTA, just so people understand, contains the medical section, the hemp extract section, the adult use section. This is every section. So that's why they're throwing all these definitions at us. Small business means a small business as defined in section 131 of the Economic Development Law and shall apply for purpose of this chapter where any inconsistencies exist. Smoking means the burning of a lighted cigar, cigarette, pipe, or any other matter or substance which contains cannabis, including the use of an electronic smoking device that creates an aerosol or vapor. So that's interesting that they are now defining smoking as including vaporizing, because there was, I think previously it was not defined as that in other areas of the law. So it's interesting that that all gets thrown in there.
Mm-hmm. All right, we're getting towards the end here.
Almost done. 4 more. Social and economic equity applicant means an individual or an entity who is eligible for priority licensing pursuant to the criteria established in Article 4 of this chapter. Terminally ill means an individual who has a medical prognosis that the individual's life expectancy is approximately 1 year or less if the illness runs its normal course. Warehouse means and includes a place in which cannabis products are securely housed or stored. Wholesale means to solicit or receive an order for, to keep or expose for sale, and to keep with intent to sell, made by any licensed person, whether principal, proprietor, agent, or employee of the adult use, medical use, cannabis or cannabis product, or cannabinoid hemp and hemp extract product for the purposes of resale.
Mm. And there you have it, folks, the definitions proposed in the MRTA that set the stage for everything to follow. Now we're about to transition into Article 2, where we explore the New York State Cannabis Control Board. And yeah, we'll begin to fast forward into there. There's going to be a lot of technical language, but we really want to draw out the foundation of what it means, who's going to be regulating cannabis in New York State, and how do they get into that position, and everything in and beyond that. So I am happy I can start if y'all would like, or if Elise, you want to pick up the torch.
Start us off, Zach. Start us off.
Cool. So we're starting at, would you call this section 7 when it's got that little S there?
Yep, that means
Section 7, Article 2, establishment of the Cannabis Control Board or board. Cannabis Control Board is hereby created and shall consist of a chairperson nominated by the governor, and with the advice and consent of the Senate with 1 vote.
Important point right there. Advice and consent of the Senate. So it's not a unilateral action by the governor. So there's a one contrast.
Yep,
and also
go ahead.
sorry, I don't want to interrupt too much. They're the Same in both bills. There's going to be 5 board members and 1 executive director. The big difference here, and it's highlighted, is there's a chair of the board nominated by the governor, but then the other 4 are really board members as provided in the next appointments. So it's the chair, you don't know how much that could have a lot of pull, right? Even with this new bill, the chair being the governor's pick and the executive director being the governor's pick, but it has to be approved, which is good.
Yeah, it's got to be approved, and we say with 1 vote, and then 4 other voting board members as provided in the subdivision 2 of this section. In addition, the commissioners of the departments of environmental conservation, health, agriculture and markets, taxation, finance, and superintendent of financial services, and the director of addiction services and supports of their designees shall serve as ex officio members in advisory capacity. So not clear what exactly that means, but there will be a community that will be informing this board.
They don't get a vote, but they're there to kind of help oversee things.
Yep. All right, so next section is appointments. The governor shall have 3 appointments with the advice and consent of the Senate, and the temporary president of the Senate and the Speaker of the Assembly shall each have 1 appointment to the board. So the governor has 3 with the consent of the Senate.
So that's really important, right? Because we know that the Speaker of the Assembly is who? Assemblywoman Stokes, who has written this bill. So it's a very, it's an important point there.
Yep. Appointments shall be for a term for 3 years, and each shall geographically and demographically demographically representative of the state and communities historically affected by the war on drugs. It goes without being said, but it must be said, the devastation caused by the war on drugs, specifically on communities of color, specifically on low income communities, it's overwhelming to address in 1 sentence, but we see the language in the MRTA really acknowledging the loss, the trauma, the structures in place and how communities have been devastated through this war on drugs again and again. And so here we see with the representative of the communities historically affected by the war on drugs. We'll see that language again and again through this bill, and it's something that I think has really brought the community together to acknowledge the wrongdoing of the past and imagining a future which is not just corrective, but inclusive and building through and forward through the harm done by the war on drugs. So I'll continue. Board members shall be citizens and permanent residents of the state. The chairperson and the remaining members of such board shall continue to serve as chairperson and members of the board until the expiration of the respective terms for which they were appointed. Upon this expiration of such respective terms, and the successors of such chairpersons and members shall be appointed to serve the term of 3 years, and until their successors have been appointed and qualified. The members shall, when performing their work of the board, be compensated at a rate of $260 per day, and together with the allowance for actual and necessary expenses incurred in discharge of their duties. No member or a member's spouse or minor child shall have an interest in any entity regulated by the board. I find it fascinating that it says minor child. And, does that mean once the child's above 18? I imagine that's when they can, well, in this case, it'd have to be 18 for hemp or 21 for cannabis. But it's interesting that, your 21-year-old child can have an interest in the industry, but not anyone else. Expenses. Each member on the board shall be entitled to their expenses actually and necessarily incurred by them for the performance of their duties. Removal. Any member of the board may be removed by the governor for good cause after notice and the opportunity to be heard. A statement of the good cause for the removal shall be filed by the governor in the office of the Secretary of State. Vacancies. I mean, this is where maybe Elise, I'll let you pick up the ball here, but there's a lot with regards to vacancies and how they're filled. I'm not sure how deep we need to go in there.
Sure. So in the event of a vacancy caused by the death, resignation, removal, or inability to perform his or her duties of any board member, the vacancy shall be filled in the manner as an original appointment for the remainder of the unexpired term. My guess is they're going to have like a list of like 20 people that they have that they've vetted for these 5 positions. And in the event that this happens, they're going to go, it's similar to like what they did at the medical program. They're going to go to number 6. In the event of a vacancy caused by the death, resignation, removal, or inability to act as a chair, the vacancy shall be filled in the same manner as the OG appointment for the unexpired term. So it'll just continue on that person's term of 3 years. Notwithstanding any other provision of the law to the contrary, shall designate one of the remaining board members to serve as acting chairperson for a period not to exceed 6 months or until a successor chairperson has been confirmed by the Senate. So that's in the event that the person is the chair. So the governor shall provide immediate written notice to the temporary president of the Senate and the Speaker of the Assembly of the designation of a board member acting as a chairperson. If the governor has not nominated a successor chairperson upon the expiration of the 6-month term, or the Senate does not confirm the successor nomination within the additional 90 days, the board member designated as an acting chairperson shall no longer be able to serve as acting chairperson and cannot extend the powers of that person. Okay, let's go into the majority. So a majority of the voting board members of the board shall constitute a quorum for the purpose of conducting the business thereof, and a majority vote for all the members in the office shall be necessary for action. Provided, however, that a board member designated as an acting chairperson pursuant to this section shall have only 1 vote for purposes of conducting business. So it's a majority of the voting board members, so 3 of the 5. Officers, employees, offices, the board shall have power to appoint any necessary deputies, counsel, assistants, investigators, and other employees within the limits provided by appropriation. I do want to make this point, and I don't know if this is something that you guys have been thinking about. There are going to be an influx of jobs. And we talked about, you know, the governor came out and said that this is going to generate 60,000 new jobs. I think that's a low number, but things that you're not thinking about, there are going to be a ton of investigator positions for the state of New York, which has good benefits. You know, you could still be in the cannabis industry. Once they really start vetting out this Office of Cannabis Management, there are going to be a lot of employees that are going to have to be able to, you know, put forth the mission of the OCM. And so just something to think about. There's going to be positions in Buffalo. There'll be positions in Syracuse, Rochester, upstate New York, because you're going to have to go look and check in on all these new operators. And so if you're just somebody who's looking to get into the industry, maybe you don't want to be a business owner, maybe you're talking about being an employee, just know that there's going to be also another avenue at the state level that should have a bunch of positions open. So
that's a good point too, because the hemp law prior to the hemp extract bill and everything, that was kind of the Wild West where ag and markets was supposed to be overseeing it, but you didn't have a lot of inspection. And so people were kind of just doing what they wanted. The law wasn't really enforced. That can't be the way adult use works. So
no, completely. So I'll just tell you that the OLCC, the Oregon Liquor Control Commission and think of it like SLA people, right? You have SLA offices in Buffalo, you have SLA offices in Western New York and in upstate. They're going to have their own branch over in this part of the state, because people aren't going to be driving in from Albany every time especially with the requirements of the lab testing. It doesn't make sense for people who are going to be located in Albany. So there's going to be a lot of those jobs, I think, coming out into play.
I agree.
Okay, so the board shall be deemed to be peace officers only for purpose of enforcing the provisions of cannabis law or judgments or orders to be for violation of, meaning these guys are going to be the ones who dictate whether you're in violation of this legislation and what to do about it. So the management shall all be in a competitive class of the civil service and shall be considered for purposes of Article 14 of the civil service laws to be public employees and shall be assigned to the appropriate collective bargaining unit. Employees serving in positions in newly created titles shall be assigned to the same collective bargaining unit as used with those who are in the Office of Cannabis Management. So it has its principal office in the city of Albany and maintain branch offices, just like we were talking about, in cities of New York and Buffalo and such other places as it may be deemed necessary. So that's interesting that they've already plugged in Buffalo there for another office. The board shall establish appropriate procedures to ensure that hearing officers are shielded from ex parte communications. Ex parte means that, like, in the context of like a judge, like it would be like one attorney talking with a judge without the opposing counsel being present. And I think that's kind of what they're talking about here. You're not going to be removed from communications that don't include you, right? Jason, is that how you read it?
Mm-hmm. Yep.
Disqualification of members of the board and employees of the Office of Cannabis Management. No member of the board or any officer, deputy, assistant, inspector, employee, or spouse or minor child thereof shall have any interest, direct or indirect, either proprietary or by means of a loan, mortgage, or lien, or in any other manner. Okay. So what this is saying, and to just move back to what I was talking about, if you do want to work for the state, you can have any money or anything involved or any interest involved in a existing cannabis business. So,
which could be something like, you might own as a landlord some investment property, like commercial property. You can't have a dispensary there. That is an indirect interest that maybe you would be like, oh, well, that's not going to affect anything, but that is totally forbidden.
I think it's interesting though
if you own equity in canopy growth, you bought it when it was getting hot, or some cannabis company that's like on the stock market. You think that's something that would count?
So it's in there, and
own any stock. I highlighted that. Yeah.
Usually they put some threshold. It's actually kind of surprising that they don't. Usually it's like if it's a publicly traded company and you own less than 1%, they don't care. That's typical.
Yeah. So this is on any premises where cannabis is manufactured or sold, nor shall they have any interest, direct or indirect, any business wholly or partially devoted to cultivation, manufacturing, distribution, sale, transport, or storage of cannabis, or own any stock in any corp which has an interest, proprietary or otherwise, direct or indirect, in any premises where cannabis. This is a very strict interpretation.
Mm-hmm.
Cultivated or manufactured, distributed. So they're saying in any corporation, if that corporation has any interest in proprietary, otherwise, direct or indirect, which I think is gonna be really tough to track. Like, what if you're investing in a corp that is like a massive investor in the cannabis, like a big Constellation Brands.
I was just going to say, if you're in Constellation and then you have to go up and then back down into, the ownership structures.
Yeah, that's a really strict interpretation. Cannabis or hemp extract is cultivated or manufactured, distributed, or sold, or in any business wholly or partially devoted to the cultivation, manufacture, distribution, sale, transport, or storage of cannabis or hemp extract, or receive any commission or profit whatsoever, direct or indirect, from any person applying. So you can't get any preferential treatment if you're reviewing these things, or hold any other public office in the state or in any other political subdivision except upon the written permission of the board. So it's not going to be people who are in state held positions unless there's a explicit approval.
Mm-hmm.
Establishment of the OCM, there is a hereby established, and we've talked about this, is going to be under the alcohol beverage control, the independent office of the cannabis management. So yeah, it's going to be like the SLA in terms of how that works. And I think that there was a budget line already for a certain amount of money that they put in the budget under the ABC dedicated for the OCM, which is a good thing for points of approval. And then I'll just wrap up with the ED and then somebody else if they want to go. ED is the office shall exercise its authority other than powers and duties specifically granted by the board by and through an ED nominated by the governor and confirmed by the Senate, which is interesting because I don't think the Senate confirmed Norm.
Yeah, I don't believe so.
I don't believe so. And then the executive director shall serve for a term of 3 years and once confirmed may only be removed for good cause with appropriate notice. The ED of the state office for cannabis management shall salary not to exceed an amount appropriate thereof by the legislator and his or her expenses actually incurred. So this will be interesting because Norm has been there for about 1.5 years as considered to be ED and has not been approved by the Senate. Okay. Somebody else want to take section 10?
Zach, you want me to do it? Sure.
Yeah, that'd be great.
Section 10, powers and duties of the Cannabis Control Board. The Cannabis Control Board or board shall have the following functions, powers, and duties as provided for in the chapter. Sole discretion to use or refuse, to issue or refuse to issue any registration, license, or permit provided for in this chapter. Sole discretion to limit or not to limit the number of registrations, licenses, and permits of each class to be issued within the state or any political subdivision thereof in a manner that prioritizes social and economic equity applicants with the goal of 50% awarded to such applicants, and considers small business opportunities and concerns, avoids market dominance in sectors of the industry, and reflects the demographics of the state. So you're really starting to see where this very much diverges from like the CRTA's kind of philosophical core. I think that section right there really kind of sums up a good portion of the MRTA's kind of philosophy behind why we're legalizing, why this is happening. They have the sole discretion to revoke, cancel, or suspend for any cause, any registration, license, or permit issued under this chapter, and or to impose a civil penalty for cause after notice and an opportunity for a hearing against any holder of a registration, license, permit issued pursuant to this chapter. To fix a rule and regulation, the standards of cultivation, processing of medical cannabis, adult use cannabis, and cannabis product. That's basically saying that they can create all the regulations. So everything's being pulled under the OCM and the board, as opposed to keeping it in these different, Department of Health, Ag and Markets, things like that. To limit or prohibit any time of public emergency without previous notice or advertisement, the cultivation, processing, distribution, or sale of any and all cannabis products, medical cannabis, cannabinoid hemp, and hemp extracts for and during the period of such emergency. They can hold hearings. They can appoint necessary people. I don't think really needs to get into that. Basically, this is just how they can structure the board. Let's see. Zach, you scroll down a little bit more.
Yep, gotcha.
To inspect or provide authorization for the inspection at any time of any premises where medical cannabis, adult use cannabis, or cannabis, hemp, and hemp extract is cultivated, processed, stored, distributed, or sold. So they are the ones that are going to be the inspectors. To prescribe forms of applications for registrations. So we will be looking to the board for when the applications start coming out. Like we just saw the hemp processor license application become available the other day through the Department of Health. To appoint such advisory groups and committees as deemed necessary, to exercise powers and perform the duties in relation to the administration of the board and the office, to develop and establish minimum criteria for certifying employees to work in the cannabis industry in positions requiring advanced training and education. That's interesting. To enter into contracts on memorandum of understanding, to advise the Urban Development Corporation to make low interest or zero interest loans to qualified social and economic equity applicants as provided for in this chapter. So you can really start to see how much control the board has in overseeing and really facilitating the intent of this law.
I just want to take a moment. There's Ram asked a question, are there license applications currently opened? There's nothing open for adult use. However, just in the past, I think 48 hours, the New York Department of Health has formally initiated its retail and processing and manufacturing licenses for cannabinoid hemp. So that's something that's been in the process, even though we don't know what the final regulations are going to look like, and we may still have another 45 days until we know what those actually look like. The application process is open for all licenses underneath, or at least the primary licenses underneath the cannabinoid hemp bill or hemp cannabinoid bill.
And if I recall correctly, the hemp extra or the hemp processor, I think it's like $1,500 for the license, or $1,000, I think, for the license, the application fee, and then like another $3,000 or something like that for the license itself if you're approved. So not inexpensive on the hemp side.
Yeah. So just at the adult use side, to kind of give everybody an overview and the timeline that we're looking at here. So you are not going to be seeing any applications for what we're talking about right now for at least another 12 months from April. And that's on the low side. So the way that this is going to all work is that there's this MRTA, what we're talking about right now, which is a legislative standalone bill that can get passed in the Assembly and the Senate through a session, which is, we're in session right now in February. If it passes in the session, it would then go to the governor's desk, which he doesn't really have an opportunity to veto, but it would give an opportunity to negotiate a lot of points in the MRTA to be included in the CRTA, or it can just pass the MRTA on its face. Either way, I don't necessarily think that we're going to see a bill until after the budget is passed. And so the budget gets passed in April. It's due April 1. And so the budget is where the CRTA would be included. I'm sorry, it probably sounds like a lot of legal jargon, but we really aren't going to know which legislation is passed until April. And then from April, the way that we're going to see a progression on the timeline is it's going to take a little bit, maybe probably 6 months for the governor's office and the OCM to create rules and regulations that are taken from other states. Those have to then be approved through comment, which could take quite a while. We saw what happened with the hemp extraction bill, commenting process. And then after that is when we would start seeing applications. So we've been told it'll be about 12 to 18 months from April when we would see applications come into effect.
And just to put it into context too, an example, this doesn't mean that this is what's going to happen, but the hemp extract bill was passed like the June of 2019, I think it was. Is that right?
Yeah.
And we still don't actually have final regs, and the application for processing just became available. The application for retail became available like a month or so ago. So, I mean, if that gives any indication as to the timelines we're talking about, 12 to 18 months might actually be quick for New York State.
Yeah, I mean, I do think there's a motivated factor because we are in a $30 billion or a $30 million. Is it billion or million?
Billion. But I think
billion. Yeah, I don't know. It felt weird saying billion, but it is billion. I was like, and so Cuomo is so motivated to get some tax revenue. Obviously, it's not the way we want cannabis to be approved, but sometimes you just got to take the grain as he goes with it. And I think there's going to be a huge motivating factor to get infrastructure in place, get licensing up and running, because otherwise he's not making any money. So I don't think he was as worried about hemp. I think now that he thinks that this is a $350 million just cannabis touching industry and a $3.5 billion with ancillary businesses, we're going to see this happen a little quicker, I think, than hemp. But again, it's New York, so nightmare,
I do want to acknowledge, so
Canada.
we're hitting the 110 timeframe. I'd like to finish this, the board section. And so, and there's probably a possibility we'll run till 120. So folks, anyone who feels like staying extra would be great. If Elise and Jason, if you guys are all right for an extra 5, I think we'll actually finish it before then, but it'd be nice to just have a full summary on this board section. And we're getting pretty close. So I'm happy to pull up the reins and start doing some reading, and then we can keep on moving.
Finish us off, Zach.
Yeah, let's do it. So I think one thing that's interesting is like if public safety or public health or welfare imperatively requires emergency action and incorporates a finding that is effective in an order summary, suspension of a license may be ordered. There's actually some interesting language about this whole bill with regards to emergency and kind of putting on a hold on the industry. So I think that I'm excited to continue to look at that stuff. Another thing that the board is in charge of doing is to draft and provide for public comment and issue regulations, declaratory rulings and guidance and industry advisories, to draft and provide an annual report on the effectiveness of this chapter no later than January 1st of 2023 and annually thereafter. Shall be prepared in consultation with divisions of the Budget, Urban Development Corporation, et cetera, and shall be required to provide but not limited to the number of registrations, licenses, and permits applied for by the geographic region of the state, the number of registrations, licenses, and permitted, approved, or denied by geographic region of the state, economic and fiscal impacts associated within this chapter, including revenue from licensees and other fees, fines, and taxation related to cultivation, distribution, sale of cannabis for medical and adult use and cannabinoid hemp and hemp extract in this state, specified programs and progress made in the Cannabis Control Board and the Office of Cannabis Management in achieving the goals of social and economic equity plan and other social justice goals, including but not limited to restorative justice, minority and women-owned businesses, disadvantaged farmer businesses, and service disabled veterans. Collect demographic data on owners, employees in the medical cannabis, adult use cannabis, and cannabinoid hemp and extract industries, impacts on public health and safety, including substance use disorder, Impacts associated with public safety, including but not limited to traffic-related issues, law enforcement, underage prevention in relation to assessing adult use cannabis and efforts to eliminate the illegal market for cannabis products in New York, and any other significant information deemed significant. The board shall make recommendations regarding the appropriate level of taxation of the adult use cannabis, that's one of the biggest things that we are currently waiting on or curious about, as well as necessary changes to improve registration, licensing, permitting, promoting, encouraging social and economic equity, etc. So basically, the board will be and shall be in charge of making the recommendations for what the industry will continue to evolve into. Functions. The power and duties of the executive director, Office of Cannabis Management. The executive director, as authorized by and through this chapter, shall have the following functions and powers and duties as provided in this chapter. 1, to exercise the power and perform the duties in relationship to the administration of the Office of Cannabis Management as are not specifically vested by this chapter in the Cannabis Control Board. To keep records in such form that he or she may prescribe of all registrations, licenses, and permits issued and revoked within the state. Such records shall be kept to provide ready information as to the identity of all licensees, including the names, officers, directors, and corporate licensees, and the locations of all licensed premises. The executive director may contract to furnish copies of the records, etc. To inspect or provide for the inspection of any premises where medical cannabis and adult use cannabis, hemp cannabis are manufactured or sold. To prescribe forms of applications for licensing and permits under this chapter and all reports deemed necessary by the board, as authorized by the board to inspect or provide for the inspection of any licensed or permitted premises, and to prescribe forms of applications and registrations, licenses, and permits under this chapter and all reports deemed necessary by the board. To delegate the power provided in this section to other such officers or employees as may be deemed appropriate. And to exercise the powers and perform the duties delegated by the board in relation to the administration of the office as are necessary, included but not limited to budgetary and fiscal matters, and enter into contracts, memoranda of understanding, and agreements on the recommendation of the executive director and authorized by the board to effectuate the policy and purpose of this chapter. Jason, you want to take the chief equity officer?
Sure. The chief equity officer shall be nominated by the governor and confirmed by the Senate. Chief equity officer shall receive an annual salary not to exceed any amount appropriated therefore by the legislature. All right. The chief equity officer shall assist with the development and implementation of and ensure the Cannabis Control Board and its Office of Cannabis Management's continued compliance with the social and economic equity plan required to be developed pursuant to Article 4 of this chapter. The chief equity officer shall establish public education programming dedicated to providing communities that have been impacted by cannabis prohibition with information detailing the licensing process and informing individuals of the support and resources that the office can provide to individuals and entities interested in participating in activity licensed under this chapter. The chief equity officer shall provide a report to the legislature no later than January 1st, 2023, and annually thereafter of the activities in ensuring compliance with the social and economic equity plan required to be developed pursuant to this Article 4. Rulemaking, the board shall provide such acts, prescribe such forms, and propose such rules, regulations, and orders as it may be deemed necessary or proper to fully effectuate the provisions of this chapter. The board shall, in consultation with the executive director, the chief equity officer, and the state cannabis advisory board, have the authority to promulgate any and all necessary rules, regulations governing the cultivation, manufacturing, processing, transportation, distribution, testing, delivery, and sale of medical cannabis, adult use cannabis, and cannabinoid hemp and hemp extract. Let's see. So, they can prescribe the forms, the qualifications for selection, books and records, requirement, methods of producing, processing, and packaging cannabis. So, all the typical regulatory stuff. This is all just outlining they have the right to enact all these types of regulations. Security requirements, hearing procedures, prevent the distribution of adult use cannabis to persons under 21, prevent the revenue from the sale of cannabis going to criminal enterprises, prevent diversion of cannabis to other states, prevent driving while impaired. That's going to be an interesting one that definitely is going to be filled by drug recognition experts at first. It'll be interesting. You know, there's no mention, thankfully, in either bill of a per se limit for THC for driving purposes, as study after study has come out saying there's no relation between THC in the blood versus ability impairment. So hopefully this will actually create another ancillary type of business where they might start trying to figure out, is there an accurate way to do this? Preventing growth of cannabis on public lands and federal property, included in consultation with the Agriculture Department, environmental. They'll promulgate rules and regulations governing the safe production of cannabis, including environmental and energy standards, because we know indoor growing is very, very energy intensive.
Don't forget, everyone, a lot of this stuff gets recovered in other sections. So I feel like we're kind of going a little quick here. These are all things that are going to be vetted out a little bit more in depth in the licensing components, those type of standards and things like that.
Definitely appreciate that. Let me see, where are we going here? I do think we can fast forward to the State Advisory Board. There's not a ton to say here, but State Advisory Board, or the Advisory Board, it's within the Office of Cannabis Management and is directed to work in collaboration with the board, as we've discussed, and the executive director, et cetera. Shall consist of 13. The advisory board should consist of 13 voting appointed members, along with the commissioners of environmental conservation, health, agriculture, markets, addiction services, and supporting ex officio members. The governor shall have 7 appointments. Temporary president of the Senate and the speaker of the assembly shall each have 3 appointments. So that's just important to know where those numbers come from. They'll be, again, appointed on a 3-year platform as well. Advisory board members of this highlighting the statewide geographic representation. I think that's an important thing. The chairperson of the advisory board and the vice chairperson shall be elected from among the members. And the advisory board shall work in collaboration with the Cannabis Control Board and executive director prior to the adoption of any rules and regulations governing the medical cannabis, et cetera. So I think that's, again, that this will be all part of the process. Advisory board will inform decision-making, or at least have influence in the conversations around. I think we're looking, the board shall change there's a bunch that goes into the regulations of ROs, et cetera, and how it'll create the cannabis revenue fund, et cetera. Total fees pursuant to this chapter shall be set to an amount that will generate sufficient total revenue to, at a minimum, fully cover the total cost administering this chapter. So that's going back to how we tax ROs to have access to the industry, and how that will create a fund that will cover the costs to operate this initially. So I think that's a big thing to consider, of like, if we're launching this, where is the money coming from the start? At one of the proposed directions is to charge the ROs specific fee, a renewable fee that shall address the expenses that are initial for this model. Let me see here. I'm just kind of the right to notice. That's pretty standard. Ethics and accountability. We can dive into the weeds, and I think we'll go back. This stuff will come up as we look at the next workshop, specifically the second to last workshop, where we're kind of looking at general provisions, because that'll come all back up again. So.
And the tax section really details how the funds are spent and all this kind of stuff. So that we go really into detail if we want in the tax section.
Yeah. So we did a little bit of a fast forward there at the moment, but I think this is setting the context for everything to follow, and this will continue to come up again and again. I do see one question by Joseph, like would counties have additional power to approve or disapprove? Elise, if you want to take a little swipe at that. Yeah. So it's a big yes.
So we're going to have what's called opt-out provisions in both bills, which would allow counties of 250,000 people or more. Right, Jason?
So the governor's bill is cities with over 100,000 or counties can opt out.
Yeah.
And then the MRTA is villages, towns, and cities can opt out.
Yeah. So basically what that means is you could be in a county that is just going to opt out of it, meaning that they're not going to get any tax revenue coming back to that county if they don't approve the recreational marijuana provisions. And that's going to be tough for people who are in very, very rural parts. I would say Long Island, if you're out there. Good luck. And we'll get more into that. There's going to be a big provision within the MRTA that we're going to be reviewing on this exact topic. And, we talk about this localities in the next, we talk about timeline. Locality and conversations with your local government are going to be massive after April. Finding out what they're looking at in terms of are they pro cannabis? Do they, want to have a stricter interpretation of the bill? Because they're going to be able to do that. They could create zoning requirements that are stricter than what's in this legislation. So
it's a conversation that I have with a lot of my clients and stuff like that too, who are like, well, we want to get property now. I'm like, you might want to hold off. We don't know what the opt-out provisions are going to look like. We don't know who's going to have control. And, it's also interesting too, is could a town effectively or city effectively zone a business out of business? Because we know there's a First Amendment case that they can't do that, except now we're dealing with a federally illegal substance. So there's a whole bunch of unknowns that we just can't predict yet.
Yep. Yes, other states do have similar opt-out provisions. Oregon, if you go to Oregon, basically all of Eastern Oregon does not. California also has opt-out. That's more so in like the Palm Springs area.
Colorado does.
So that's a very standard scenario for legalization. This isn't shocking that they're doing that. It's just it puts a lot of power in the hands of the local government.
But it's a carrot and stick approach. You can opt out, but you forego the tax revenue. So,
Right. And that really is for a lot of these, especially just during COVID and stuff like that. I think we're going to be hard pressed to see a lot of counties say no to it, other than the ones who are like politically opposed to it.
Mm-hmm. There's also the whole, I've heard too, like the wait and see approach is, we're going to opt out for a year or two, see how this goes, and then opt in. Whether that's a valid way to go about it and they miss the boat, I don't know.
Yeah, totally.
Well, great, everybody. We've had solid participants. We started off with about 40 plus people on this call, and we're at a solid 35 still through and through. And as you know, we could probably all talk about this all day. But again, I'm stoked that this is the starting point of this, over a month-long conversation we're going to have every Tuesday from noon, maybe we say 11:20 or noon to 1:20. Pardon me there. Because it's dense. There's a lot of layers. We got a lot of questions. But again, Elise and Jason, I am so grateful for your guys' perspective, your expertise here. And this is, we're starting off something fun that's going to go a very long way. So thanks to everyone in the crowd. Thanks again to our members. Thanks again to Harris Beach Law Firm, our sponsoring member, for all your support. And we'll see you all. Please consider. So this event's $10 for the public. It's free for members. We've had a big surge in individual members. There's different tiers, $65 for an individual, $200 and something for a business membership. And that allows you to have more access to, more people can have access. Just again, know your contributions go a long way. We're here to serve, and we welcome your feedback if you got more questions or things that you would like to learn more about or focus on as we continue to grow through this industry. So everybody have a great day. Elise and Jason, thank you both so much. And we'll see everybody soon. And this recording will be available to everybody who was in attendance or registered. So just at the very least, register for the future ones if you want to stay connected. All right, everyone, take care.
Thanks, guys. Thanks for participating.
Yeah.
Cool. Bye, Zach.
Hey, see you, Elise.